Yeah.
Okay. Again, I wanted to share a disclaimer that this
Sure.
call is being recorded, and if you do not consent to be part of this recording, please drop from the call and listen to the recording later. And this is a continuation of our previous call on the discussion of legal will. Okay, over to you, Nikhil.
Yep, no, absolutely. Just answering the questions. So yes, coming back to the previous question, that if somebody dies without a will, and that's why it could be really risky, because so many situations, because when I was researching this particular topic, I mean, although it's kind of a little morbid in the sense that nobody wants to think about their own death, right? And everybody wants to live forever with their families and loved ones. But it's a very relevant and valid topic, because this thing can happen anytime, right? And when it happens, if you have not planned it properly, and more importantly, in cases where there are family complications, like, for example, if it's a straightforward case of a husband and a wife, and living in a very loved relation and just have the parents, then it's pretty kind of straightforward. But imagine a scenario where you have, let's say, siblings involved, and and not having the best of the relationships, or even kids, two kids both going in different directions. So things can become a little complicated. So proper planning is required.
So when we appoint beneficiaries, like say I have 10 people that I want the amount to be divided, do I need
Correct.
to mention like how many percentage I want to allocate to each of them?
Absolutely. So it is completely your choice, Shilpi. So if you want to, as I said, I was giving you the example of the two methods that, pool and then split. If you want to adopt that, or, a named gift, you could choose any one of that. That's completely your choice. You could say, hey, you know what, the car bearing number plate this and this, bought on this, and you have to be specific. I mean, the more specific you are, the less complication or the less confusion it will cause, right? So you can absolutely say that this car should go to my spouse. And you could also say what has to be excluded. We're not only talking about inclusions. We can absolutely talk about exclusions. So you can be as detailed. And I think the whole idea about this will part is you have to be very detailed in the planning. You have to be very detailed, because if you are not detailed, then the issue of confusion would come into picture, right? Because it has to be clearly laid out.
Okay.
And also, I would like to point out one other thing that I just remembered is, if you're trying to create a gift, let us say for a grandchild, that is very complicated. It is not very straightforward. So if the value of the gift is more than $10,000, there is another, I believe, a law or agency that comes into the picture called the children's lawyer, something of that kind. I'm struggling to remember the name. My apologies. But that comes into the picture. So it's not as straightforward.
Okay. So is there any tax implication on these gifts?
Absolutely. Tax implications are definitely there. And that's why when, you talk about probating a will, some people would adopt different ways to do that. That keeping some part, so they will create multiple wills. For some one particular will for incorporations, one particular will for let us say the other assets, because they will be treated differently. And then again, I'm not the expert here, but all I know is that tax implications definitely arise, and there is a reason why people choose different methods of creating a will for the same kind of asset.
So if I have like I cannot create multiple will for same assets, right?
No, you cannot. No, you absolutely not. So if there is a house in consideration, of course, it has to be addressed in one particular will. But what I'm trying to say is you could have multiple wills for yourself, which can address to multiple portions of liabilities and assets that you have. And similarly for geographies too. So you could very well say that, hey, you know what, this particular will covers only the assets I have in Ontario, and then this particular will covers the assets I have in India. And those could be two separate documents. Now, whether the holographic will be valid in India is a separate topic.
Okay. I cannot.
Question. So do I need to keep the will at the executor's place, or how the executor will get access to the will?
Yes, so that is completely your choice. What you try to do with the will. You could keep it at your house. You could keep it in a locker. You could keep it at a law office. You could do whatever you want to do with it. But the idea being that when the death occurs and the executor tries to find a will, they should be able to find the original will. Now, keep in mind, finding the original will is pretty important because a lot of let's say financial institutions will demand a copy of the original will before they proceed with the further exercise of distributing the assets, and the assets have to be very clear, so there cannot be a confusion. So you have to make sure that you are explaining it in great detail, right? So for example, like, I mean, you could simply not say that, let us say that I'm giving you a very, not, maybe it's not a relevant example, but let us say, assuming you say that the house value when it's sold will be $1.5 million, and then that 1.5 should be distributed in blah 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 proportions. But actually you realize that when the house sells, it only sells for 800K, right? And your liability is already 900K. So that basically defeats the purpose of the will.
So is it wise to mention percentage instead of values?
I mean, that's again a personal choice, and also depends on the type of asset. For example, if it is the only possession the person has is a vehicle, then of course that doesn't come into picture, right?
Yeah, makes sense. Thanks.
Yeah, no, you're welcome.
Another question, like in terms of assets, when we are talking about the physical asset like a house and a vehicle. What happens to the assets that we have through RRSP or TFSA, all the bank investments?
Correct. Absolutely. So they are definitely covered under the will, but RRSPs, TFSs, and all that have a separate tax implication, which I found was requiring a little more effort to understand. So I was just a little, lazy to get into deep detail of that one. But yes, RRSPs and TFSs are covered under the assets. Now, once you asked me this question, I was actually thinking about intangible assets as well, that whether that can be covered or not. And to again, which I would have to apologize that I'm not an expert on intangible assets as well. No, I would not know.
That's for our homework, I guess.
Sorry.
Okay. No.
Shilpi, regarding RRSP and TFSA, I think the mention of beneficiaries is very important when you are making that thing.
Very good points.
Once you mention the beneficiaries, that works is most important thing. Either beneficiaries, contingent beneficiaries, or backup the trustees. So that will decide your assets going where.
You are absolutely right. And it reminds me of what actually I think I had read. You're absolutely right. Very good point. And thank you for mentioning that RRSPs and these have an explicit place where you mentioned the beneficiaries, and that will be the way it will be decided. You're very right.
Okay. Do we have any more questions?
So Nikhil, I have a last question from my side. So when we are like creating a holographic will, let's say just a handwritten will, right? So is there any specific template or some probably like the executor or the court might ask for some specific keywords, right?
No. So
nothing?
I think no, there are things that you have to keep in mind.
Okay.
What I was answering is there's no template. So you do have to make sure that you are explaining, let's say for the start, your name correctly, your legal name, right? Valid point. The day it was created, the fact that you are of sound mind on that particular day, you are aware about what you're trying to imply in that will. So those things have to be there. The signature has to be very, very clear. You do not need to write anything below the signature. So there are certain things you have to keep in mind. You're not making any contradictory statements in the will. So those are absolutely the key components. What I was trying to say is you are able to create a holographic will at the comfort of your home with no other assistance. That is something you could do.
Yeah. Okay.
And is there like a limitation to how many pages it has to go? Do we need to sign on each and every page?
Well, absolutely. I think that should be strong. That is strongly recommended, because a lot of times what happens is when the person dies, the wills can be challenged in the court. And at that time, the courts will try to judge different aspects of the will. One, for example, one of the articles I was reading talked about someone, taking to the court a copy of the will and making a claim that the original will is lost and it's not traceable. So the courts will take a very keen look at that, because also keep in mind, the author of the will has the right to destroy the will. And destruction could be through, just burning the will, tearing it away, and that's all considered destruction. So the courts will take a hard look at the authenticity of the claim, whether that copy of the will is the copy of the will and there's no original will that remains. So it is incumbent on the author to make sure that those questions are answered beforehand. There are tools and means available to get your wills registered. But you should know that that's not, that only, I think, Quebec and there's another province that allows for registration of wills. Ontario doesn't. So then you will have to find a means or a way to make sure that you are using this particular tool to get it registered so that remains the final version.
So it's like a digital space, not
Not
a
only
physical
that,
space.
like you could, for example, take the service of a law agency, law office, right? And you could go to them and say, hey, you are the legal representative, and I completely vouch that this particular will that was created on this date, and this version is, and the copy of which you have in your law office is the final and the original version of the will. Should the lawyer change, should the law office move or closes down, that is something of a scenario you will have to again think of. It is similar to planning for the lives of the beneficiaries. Like who would think of a scenario that the child would pass away before the parent does? Nobody would want an unfortunate situation, right? But doesn't mean it cannot happen. So that kind of thought process has to go in the will, that should such a situation occur, what happens next? Same goes with the executor too. So I could write, okay, you know what, I trust my friend completely. And because he's not a beneficiary, now keep in mind, one of the key components of the will also is that you are not writing a will for something you have been a beneficiary. So like my parent giving me something, the parents are still alive and I cannot write a will for that thing, right? The will basically means it is your assets and your liabilities that you're talking about. So I know that there is a friend of mine who I can trust, who does not have a vested interest, and who would be open, because the executor of the will can anytime tell that they are not willing to continue with that process, because it's a lot of work. It's not straightforward, and they should understand the implications of it. As I said, they are not doing any favor by doing it. They can be compensated, and if they're not doing it properly, they can be held liable for that. When I say held liable, does not mean that their own assets will come into the picture, but they will be liable for the proper execution of that will.
Can an executor back out at, after they have agreed? Like
I think yes.
Like during the time then when the person is no longer in picture and when it is the actual time for the executor to execute stuff.
Right.
I
don't think because I don't think it's a contract. A will is not a contract between the executor and the person who's writing the will. So I'm not sure how would the court or the person or the family would hold the executor accountable to execute the will, because it's not under a contract that they are doing that service.
Okay.
It's based on a nomination that they are doing it.
Okay. I do have one last question, but if anybody doesn't have anything, then I can go ahead and ask. It's a slightly different twist.
I have one question. This is Chiranjit here.
Hi, Chiranjit.
So, hi. So when you write a will in Ontario, like, does it only allow you to write the will for every property and things that you hold in Ontario?
No.
Or you can also include everything back in your home country or anywhere?
Anywhere. But
so what happens, let's say somebody has a will back in India.
Exactly.
Somebody has a will here in Ontario. What happens in that case? Which one takes providence?
That's what I was trying to explain. So if you have a property in India and that property is challenged by a relative of yours, then of course the jurisdiction will be that of India. So what I'm trying to say is, if you are the owner of these properties, then you have to make sure that you are writing the wills in a way, whether it is through a single will or a separate will, that each of the will is legally covered under the jurisdiction it should be covered under.
Sorry to interrupt.
Yeah, no, so that is what I was coming to. So basically, the idea is that the jurisdiction is supreme. So Ontario's jurisdiction can be only enforced in Ontario, not in India.
Okay. So just one scenario, like for example, let's say there is a shared property held by husband and wife, and both of them has written their own set of wealth. Okay.
Right.
So let's say the husband passes away before the wife. How will the executor, anybody, make sure that, like, I'm not able to frame the question accordingly. So
no, I understand where you're trying to get to, and let me try to answer based on my understanding. So first of all, both the wills should not be contradictory. So what that means is, if the husband says that in case of my death, my property should go to my daughter,
right,
whereas the wife says in case of my death, my property should go to the son, and the property we are talking about is a single house. So this is contradictory.
Right.
So there should be no contradiction. So I will now tweak the example to make it in a case where both the husband and wife have just one child, and where the father says that in case of my death, the property should go to my child, and the wife says the same. And in case one of them passes, the law of survivorship, the joint tenancy comes into the picture, which clearly tells that the survivor will be the person who will get all the property, 100% of it. And then that person becomes the owner, and basically the purpose of the deceased person's will terminates there, because now this person is the new owner.
Okay.
And the next step would be based on the will of this particular person.
Okay. So you are saying that is suggestible that, or suggested that, like, the husband and wife, they discuss while they make their own separate wills, so that there is no contradiction later on.
Absolutely. Contradiction is a very big area of concern, because when that happens, then it goes to the court for decisions, because one of the parties or both the parties are not alive to present their case.
Okay. All right. Makes sense. Thank you.
Is there anything called joint will? Both husband and wife sit together and make a will.
I believe so. I believe so, because the situation should be such that the assets are common.
Yeah, definitely. Yeah,
right. We're not talking about separate assets, because
yes.
obviously the husband will not have any control over.
Yeah, some joint bank accounts, and then maybe house, kind of.
Correct. But the separations should be maintained, right? That the bank accounts treated separately.
Yeah.
I don't remember if we answered this question in the previous call when I dropped out. How much does it cost to make a will in Ontario?
No, when you were creating that Zoom link, that is what I was trying to answer. The cost implication, as I said, is totally from zero to all the way. The more expensive the lawyer you engage, the higher the cost is, and of course, depending on the complexity of the assets and the liabilities. So, it could go as low as, like, say, $200, $300, $400 to, a large amount.
Okay. And one last question that I've been meaning to ask, like, can I appoint an executor if I'm making a will here? Can my executor be a person who is based out of India, or that person needs to be a Canadian?
Yeah, so it is only logistically challenging. There's nothing in the law that stops you from appointing anybody in the entire world as your executor, or even having multiple people as your executor.
Oh, okay.
Yeah, you could have 3 executors, 5 executors, 10 executors. It's totally up to you. But then you should be sure that they will get along well and work as a team, because if that doesn't happen, then basically the whole purpose is defeated.
Got it. Okay.
Yeah.
Hey Shri, I see your raised hand. Do you have a question or point?
Yeah, because I actually had an executor who was based in US, and there were a lot of legal repercussions for it, for which my late husband's estate was not formed, because there are certain signatures that you need to do, for which there are a lot of legal repercussions. So that's why I'm kind of confused with this answer.
Oh, okay. So, based on my understanding of the Ontario law that I have read, you can have multiple executors. It's completely your choice how you want to appoint them, and they can come from any part of the world, as long as they are able to, assist in the process.
Okay, but for my case, it was completely different. So the executor was based in US, and the bank where I was supposed to move my husband's RRSPs. They were like, we will not be able to get his signature. There are a lot of legal bindings in it, and it was a huge issue.
So what you're saying is that you faced issue because the executor was not based in the US. Was that the issue there?
No,
or
he was not a Canadian resident. He was a US citizen.
Sorry, I'm just a little confused. So you're talking about a case that happened in Canada or in the US?
In Canada. I'm talking about my case.
Your case that happened in Canada. And the
In
person,
Canada.
oh, and the person was US based.
The executor was based in the US for the bill.
I see. And they were not acknowledging that?
Yeah, the bank was not acknowledging it. There were a lot of repercussions. Like they said, there's a lot of legal binding in it, and it's difficult to get signatures. So finally, Sorry?
My question is, did they disallow it?
Yeah, they disallowed it. So I had to for every little thing, for the like for example, to get the car transferred to my name, the executor had to travel from US over here to sign the papers. They would not send the papers to US for signing.
No. So this is a different answer to the question that I'm asking. So
okay.
In this situation, you are explaining that the executor had to be physically present in Canada to execute the will. What I'm trying to ask you, that is a separate condition.
Yes.
But did they disallow him from being an executor at all? Like, let's say if he was willing to travel to Canada, would the bank still say that, no, we are not allowing you as an executor? That's what I'm trying to ask you.
No, that they will not, because the will...
Exactly.
They will not say that. Yeah.
That is what I'm trying to say. So my answer was that executor could be located in any part of the world. Now, whether the banks have a requirement that the executor be physically present in Toronto to execute that will, and they will not accept electronic signatures, that is a different set of questions.
Yeah, but I agree. That's a second set of problems.
That's a second set of problems. Yeah. So
yes.
that is something that you have to think
Technical
about.
problem than legally, banks will allow anybody, but that
yes.
only
Now, for
requirement.
example, yes, Shilpi, sorry, but now, for example, let us say you are appointing somebody in India as an executor, and that person is inadmissible to Canada from the immigration perspective. And the banks are absolutely clear that the person has to be physically present as an executor for them to verify. So then that's a very difficult situation. That is something that the person who wrote the will should have thought about. So that is why I'm saying that when somebody is creating the will, there are lots of situations and cases that someone has to think about. Because a minor complication, it does not necessarily depend on the dollar value. Like banks and courts try to be, not banks, courts try to be reasonable. The test of reasonability is an important test that the court uses in different cases. So maybe my example might sound a little exaggerated or not even applicable here. But what I'm trying to say here is to make a point that if the total value of the assets is $1 million and the confusion is about $100, that could actually stall the process. Because you have not been clear in your instructions. Or you could have been contradictory in your instructions. So this requirement that was explained just recently in this example, where the executor had to be present in Canada, it's a separate situation. Because executor is allowed. That is what I was trying to convey. They are allowed. They can be from US, they can be from Australia. Now, whether the banks...
When we are making that decision, we have to be very careful.
We have to be very careful.
As you said, like immigration can hold that person, and that person may not be allowed in Canada, right?
Absolutely. So you're stuck.
Okay.
Like even for real estate transactions, some of the lawyers will allow for electronic signatures to take place. And some of the lawyers won't. Not that legally it is not allowed. Electronic signatures are allowed. There is a proper Electronic Signatures Act, right? But should you go to a lawyer who doesn't allow this and the spouse is not present, then of course you are leading yourself to trouble. Like there's a homework you have to do before you're making that call.
So we have to do our own research, read all the fine prints, and
yes, it's not that straightforward. The other approach could be to make it very simple. Is that like the way that farmer wrote? If I die in this mess, all my assets go to my wife. That's a blanket statement. Or just including all my assets and liabilities go to my wife.
No, I'm just thinking like when I create my will, I have to be very careful that I don't put my parents as an executor because they are getting old. They might not be able to travel to Canada and execute if I'm not in the picture, right?
Absolutely. Absolutely. Fair point.
Okay, I think.
Just a question. This is Udata. I am just thinking, like, can we do like primary executioner and secondary executor?
Absolutely. Absolutely. You could do that. And that is definitely recommended because, God forbid, what if the executor dies just after the individual dies?
Right, because that came in my mind. Like, if accidentally it happens, our executor dies before us, then we have to again change the whole will.
And the person is already dead. So the person is already dead. The individual is already dead. The executor is dead. It becomes intestate.
Right.
So plan B is very critical.
I have a question in addition to that. Like, if the executor and the person both pass away, then doesn't, like, who manages the estate? So who's the next person kin who will manage the estate of the?
No, it becomes intestate. So if you do not have what is the right word? Substitute. Not the substitute. The backup
secondary kind
option.
of.
Then it becomes intestate. Yeah, then it again goes.
So you have no control over your you don't get anything from the estate then.
No. The estate is, you will get everything from the estate, but it will follow the process of the law.
Okay.
For example, I was mentioning about the particular law that becomes applicable when the properties are intestate is the Succession Act, where the distribution of the properties, that will come into the picture.
Okay.
But then there will be court-appointed executor, and then there will be fee for that, and all those expenses will be then taken care of, and then gradually whatever will remain after going through the entire legal proceedings is what you will get.
Got it. Okay.
So
thank you. That makes sense.
Yeah, absolutely. You're welcome.
If there are properties and things which are like named both after the husband and wife, and let's say the husband dies, and if there is no will, like the shared property can still be the property of the wife, right? Like, or that still goes under.
In real estate, it is pretty clear. Real estate considers those properties as joint tenancies, and the property is totally transferred to the wife or the survivor spouse. Now, for other assets, most likely it should be the same principle here there too.
Okay.
But
How
in real
true is
estate,
this statement, Nikhil? Sorry, go ahead.
In real estate, the law is pretty clear. There is a proper joint tenancy and the law of survivorship where the spouse is the beneficiary of all the real estate assets of the deceased spouse in case of joint tenancy.
So let's say at a very high level, right? The main things in Canada, what it could be, right? Let's say your house, maybe your vehicle, and maybe your your bank accounts and all the investments that you have.
Right.
So let's say all of these things you have with your wife, like everything is not in your name, all of them are joint with your wife.
Yeah.
Right. So, and let's say the husband dies. So you are saying the real estate is easy, but what happens to the other things?
Well, if it is a joint ownership, it means there are only two owners, right? And then typically the assignment of the other deceased persons. So I'll take up this example of RRSP. This is an asset, and which was correctly pointed out by the person who spoke. Sorry, I struggled to remember who mentioned that. Joydeep, yeah. So the same story, like in that, for example, it is clearly mentioned that, in case of my death, 100% of my RRSP goes to my wife. So it will follow the same pattern for your bank accounts, where you have a nomination when you fill up the nomination form, right? Similarly, you have it for insurance, where you have a nomination form, right? So that will follow the process of those nominations. Whereas the real estate will simply follow the law of survivorship.
Okay, I see. Okay, but in case of vehicle, I think that is not there. So maybe that will be a point of discussion.
That is a point of discussion, absolutely.
Yeah, I can share my example. For vehicle, I had to go to Service Ontario and get it transferred. And they asked for the will and they asked for the executioner to be present, so it became hassle.
Exactly.
So it has to be transferred.
Exactly.
But the name of the vehicle was in your husband's name, right?
Yes, it was not in my name. It was in husband's name. The insurance, I was added on to the insurance, but the vehicle, the VIN was in his name.
Yeah.
I see. Okay.
Okay, so we have another 8 minutes. So we magically spoke for, so many minutes, which is a great conversation.
There's a
And
lot of-
any last point or any last questions that we want to take?
I have like a very. I joined in late. I'm sorry, but probably like the basic question: does it make sense to write your own will, or does it make sense to get it written by a lawyer?
See, I think the way I look at this situation is that every profession has skilled and unskilled. Not unskilled is not the right word, but I would say proficient and less proficient professionals. So if the idea is to get it like watertight and make sure that every aspect of it is covered, and one doesn't mind paying for those $1,000-1,500, I think getting a lawyer's help is definitely recommended. But if the assets are in such a way that I believe, let's giving an example, that all I have is just one house, that is all it is, and I don't have any liabilities, I think that should be a pretty straightforward case.
Got it. Thank you.
You're welcome.
Any more questions?
But more than anything, I must convey to all the participants that this was an absolutely fantastic experience for me. I was mentioning to Shilpi as well, one of the goals of my life was to learn Bengali, which I tried to flaunt a little when we met at the Durga Puja, but I was miserable at that. But love to be a part of this group, and would love to stay in connect and have such conversations in the future as well.
We really appreciate your time, Nikhil. Thank you so much for joining today and sharing whatever learning and experience you had. So thank you for joining. I'm sorry, I may have, interrupted someone.
Yeah, somebody was trying to speak.
Yeah.
No, nothing. I was just saying that maybe we should have this entire conversation in Bengali itself, as Nikhil knows.
Good way for me. Then it will become a two-way traffic. I would learn Bengali as well, right?
How much you will understand, that's a different conversation.
That's a different. You are there to assist, right? Yeah. My suggestion is that like we can have if the group is okay with that, there are so many more topics which will impact the lives of all of us included. Things like as I was mentioning to Shilpi before this call, immigration, real estate, mortgage, jobs in this country, paths to move here, education programs. So those are other things that more than happy to kind of volunteer.
Sure, we will definitely keep in mind. We have this info session, we call it Kolkata-Days info session series. So we kind of pick whatever our members are willing to learn more on those topics. So we'll definitely keep you in mind, and when those need arise, we will definitely reach out to you.
Thank you so much.
Yeah. No, I think it was a lovely conversation, and we learned. I hope everybody learned something more. We are a bit more educated than we were before this call on the legal will topic. And yeah, if anyone has any questions for Nikhil, please feel free to ping me, and I'll make sure to pass his information to you guys. Thank you so much. Have a lovely evening.
Thank you
Bye.
so
Good
much.
night.
Thank you so much.
Thank you.
Thank you.